Rules Committee come to order. Today, the Rules Committee will consider H.R. 2130, the Red River Private Property Protection Act. This legislation would establish whether lands along the Red River between Texas and Oklahoma can continue to be privately owned or if they should belong to the federal government. The Bureau of Land Management has estimated that nearly 30,000 acres of land along the Red River may be considered public domain, causing a major concern for law owners who hold titles and pay taxes on this same stretch of land, which many of these acres have been passed down over generations and generations. This bill will ensure tools are in place to settle this matter, and I believe it's important that we are taking this piece of legislation up today. We have Tom McClintock, and we're delighted, Tom, that you are here today. And quite honestly, it's also great to see one of our own, Jared Polis, who shares the equal title of caring a lot about the lands of this great nation. And certainly, Tom, you know well because you have national parks, including Yosemite, one of my favorite parks that I've been to several times, and forests in California that are important, so you understand the importance of land, where people are from, and the attributes that are important to that. Also, we have Mr. Polis, who comes from Colorado. It's a beautiful state, great people, and good country. So, two people here at the Rules Committee today who care very much about land and people who live on them. We're delighted that you're here. Before we come to either one of you gentlemen, I'd like to defer to the gentlewoman, the ranking member of the committee, Mrs. Slaughter.
I have no comment.
No opening statement today. Louise, thank you very much. Gentlemen, you know how we operate up here. You represent thoughts and ideas not only of yourself and your party, but also common sense ideas about what we ought to be debating in this Congress, how we ought to focus on important issues, and I'm delighted that both of you are here. And of course, we have one of our finest stenographers who is with us today. She speaks mostly Texan, so she gets my language down. But if you have anything in writing that you want to leave behind, it'll help her get through that adjudication also. The gentleman from California is recognized.
Thank you, Mr. Chairman, and members of the committee. I want to thank you for holding this meeting on H.R. 2130, the Red River Private Property Protection Act, introduced by Congressman Thornberry. The Natural Resources Committee favorably reported this bill in September, and on behalf of the committee, I ask for a structured rule for its consideration with appropriate time for debate. This bill prevents the federal government from seizing thousands of acres of private land lawfully owned by American citizens along the 116-mile stretch of the Red River between Texas and Oklahoma. In 1923, the U.S. Supreme Court established the gradient boundary survey method for determining the boundary between Texas and Oklahoma and establishing property rights over this land. Pursuant to these property lines, which for nearly a century the federal government did not question, deeds were acquired, sold, purchased, in some cases passed down from generation to generation, as you just said. These property owners, in good faith, dutifully paid taxes on these lands year after year, invested in those lands, maintained them, cultivated them, improved them, and in many cases purchased them from others who had done the same. Now, 90 years later, the Bureau of Land Management has announced that it, and not the rightful property owners who purchased the property, owned deeds, paid taxes, and invested their work and resources into this land, not the property owners, but the government is the rightful owner of this land. This clouds the property rights along the entire 116-mile stretch of this river. This sweeping claim is based on a limited number of BLM surveys that covered just 6,400 acres and which essentially ignored the 1923 Supreme Court decree that originally established these boundary lines in the first place. H.R. 2130 rights this obvious wrong. Called the Red River Private Property Protection Act, it requires the federal government, in conjunction with states, to make clear the true ownership of this property. To do this, the bill requires the BLM to disclaim any right, title, and interest to certain lands along the river, perform a new, accurate survey in conjunction with states and tribes to resolve clouded title, and gives right of first refusal to property owners to reacquire their property at $1.25 per acre, the price set by the Color of Title Act for disputes of this nature, and to sell the remaining surface rights to the public at fair market value. While ensuring that local landowners have a judicious, practical process to firmly establish title to their rightfully owned land, it's the most vital element of this legislation, but also preventing the BLM from managing this land in the future is also important. The regulatory burden and uncertainty associated with doing business on BLM land would have devastating impacts on local landowners and users and make it much more difficult to encourage economic development in the area. Chairman Bishop has filed a manager's amendment. It ensures that nothing in the bill would create or reinstate a tribal reservation, ensures that nothing in the bill alters the valid existing mineral rights of the Kiowa, Comanche, and Apache nations. It allows affected, federally recognized Indian tribes to be part of the survey process and allows landowners access to further judicial review beyond BLM's administrative appeals process. This bill rights an obvious wrong. Government exists to protect our natural rights, including our property rights. This bill realigns our government with its stated purpose.
Mr. McClintock, thank you very much. The author would be very pleased not only with the presentation, but your choice of words and the specificity which you provided. Mr. Polis?
Thank you, Mr. Chairman. H.R. 2130 would require the Secretary of Interior to disclaim all right, title, and interest to the land located south of the South Bank boundary line in the affected area. The bill would also require a resurvey of the land by the Texas General Land Office, and it would nullify the previous BLM survey, creating even more uncertainty around revenue opportunities for the tribes. Disclaiming federal interest in the affected area would jeopardize longstanding relationships between the federal government and Native American tribes. The Kiowa, Comanche, and Apache tribes receive 62.5% of royalty revenues generated by oil and gas leases along the Red River. Yesterday, the Natural Resources Committee received a letter from the Kiowa, Comanche, and Apache Intertribal Land Use Commission, and I'd like to submit that to the record, Mr. Chair, without objection. The letter expressed grave concerns that H.R. 2130 is a threat to the livelihood of the tribes, as well as an assault on their property. The letter specifically states, I quote, "Passing a bill to take away our interests brings up dark memories of the removal era and past discrimination against our tribes. We cannot agree to stand by and allow our land to be taken once again against our will. We should not just sit by and allow this injustice to occur." The manager's amendment filed by Natural Resources Committee Chairman Bishop does pay lip service to those concerns, but it's my understanding, based on the legal analysis of the committee and the tribes, that it would not actually fix the problem. Fortunately, Representative Cole has filed an amendment that does address these concerns that are outlined in the letter. Mr. Cole's amendment provides federally recognized Indian tribes holding reservation or allotment land with the right of first refusal for any federal land offered for sale under the provisions of this bill. This will guarantee the tribes do not lose their vested interest in land along the Red River. In addition to potentially losing revenue from mineral revenues, tribes have also expressed concern about access to water. Water is very scarce in this arid region, and tribes rely on access to the Red River, and H.R. 2130, if not amended, could also threaten this critical access to water. If we want to do what's right by the people of Oklahoma, the affected tribes, and the taxpayers of the United States, this committee should make Mr. Cole's amendment in order, and I yield back.
Thank you very much. Mr. Polis, have you ever visited this area, this arid land that you're talking about?
I've, not this particular plot, but southern Colorado has a lot of similar, very arid land as well. We also share a border with Texas.
I fly over it every week, and I'm not trying to take you on at all, but I would not have described it as arid land. I would have described it as a land of sometimes milk and honey. Because in fact, it lies in Texas and today some parts in Oklahoma. And these guys get about have lately gotten so much rain, but I'm not trying to take you on. I just ask a simple question.
Well, and again, you know more about the affected area than me, but it's my belief, and you can certainly correct me if I'm wrong, that like most areas of Colorado, agriculture in the area needs to be irrigated, and therefore you need water rights, as opposed to, for instance, agriculture in areas like Iowa and Wisconsin where there's enough precipitation. So to have commercial agriculture, irrigation, and water rights on top of what naturally falls generally needs to.
Well, I
occur
would
in this
agree with
region.
you. I would hope that whatever the answer is, that I'm sure Mr. McClintock could register this also, whether it's used by the federal government or the people who own the land today. I think they would intend to need water. It's really a question of who it belongs to. And I've got one more question, I think, for you, and that is, you referred to, there's an agreement of 62%. Was that you, Mr. Polis, that talked about?
Yes.
Revenue sharing of,
For the tribes.
how much revenue comes in today?
It's my understanding that a lot of the discussion hinges around the potential for much greater amounts of
Potential
revenue
more
in the
than,
future.
so it's just trying to make sure that we knew ahead of time, if there was revenue, here's how it would fall.
I think
So I think that's fair for the tribes. I hope
Yeah.
that they help negotiate that.
I think that it's based on the geological characteristics. There's potential for substantial revenue from this
What's
area.
in Texas? Absolutely, there would be. Any place in Texas has awesome opportunities like that, especially in the congressional district that Mac Thornberry has. It's just full of natural resources. Okay. Mr. McClintock?
If I could add, Mr. Chairman, the BLM survey that Mr. Paulus referred to is not a comprehensive survey, it's an estimate. It's a guess based on sampling 6,400 acres of some 30,000 that are disputed. And that sampling ignores the 1923 Supreme Court decision that established the process that set the boundaries in the first place. The manager's amendment speaks to many, perhaps not all, but many of the objections raised by the tribes. The tribes are asking for the right of first refusal on every acre of land disputed, including land they have never owned and never had title to. What they're asking for is to be put ahead of the property owners who year after year paid the taxes, cultivated and worked the land, poured their blood, toil, tears, and sweat into that land. And so whether that land is seized by the federal government or by a local tribe makes no difference to the cause of justice that this bill serves.
Yes, sir. Yes, sir. Mr. Stivers, do you seek time? I do not. Mr. Collins, do you seek time? Thank you very much. Either of my friends from the gentleman, Judge Hastings.
Thank you very much, Mr. Chairman. I have a couple of questions of Mr. McClintock. Do you agree, Mr. McClintock, that there are overlapping claims in this particular matter?
The only overlapping claim I'm aware of is that the federal government, 90 years after these boundaries are set, has suddenly decided that it and not the property owners is the rightful owner of this land. That is the issue.
Do you agree that there are missing or unreadable records with reference to this matter?
I'm not aware of that, no.
Do you agree that Texas and Oklahoma have competing claims?
Those competing claims, as I understand it, were settled in 1923 when the Supreme Court established the gradient boundary survey system. The survey was done, the boundary lines were established, and 90 years of vested property rights have since appertained to that survey and because of that decision.
Do you agree that the disputation that has been ongoing has been as much as 200 years?
The only disputation at present is between the United States government, the BLM, and the rightful property owners who have held this land for generations.
Then how did the Texas General Land Office, where this legislation would repose the decision, how did they take priority over the Bureau of Land Management? Or to carry it a step further, what would Oklahoma do if they had a similar Bureau of Land office, and they probably do have
My understanding of the
some?
legislation is that Oklahoma is fully involved in the survey and in the certification of the survey. The lead agency is the General Land Office of Texas, but Oklahoma is fully involved and does.
Well, I maintain that it has been a point of contention and dispute for 200 years, And I want to take issue with you regarding something that you just said, and that is that the tribes, and I assume then we're talking about the Kiowa, the Comanche, and the Apache tribes. Your quote was, "They never owned it." Mr. McClintock, I think they owned it before there was something called Texas or Oklahoma. As a matter of fact, I think they owned this whole thing we call America at some point before any of us determined to take what they own.
Does the
So
gentleman...
I disagree with you totally about whether or not the tribes owned it. I hear you about people that have made investments, perhaps in timber, oil. Now that it's discovered, creates yet an additional set of issues. But I don't agree with you that the tribe did not own the land, or certainly they have issues that I believe that Texas would trample, and that bothers me, and therefore I would be very much opposed to this legislation.
Does the gentleman seriously suggest that the entire United States should be returned to the native Indian
No,
tribes?
I don't think it should be returned
Well,
to them.
but that's what you're arguing with respect to these
I would like for
particular
us to
lands.
recognize that when Columbus allegedly discovered America, that the Native Americans must have been running down the shoreline saying, "Discover me," because they were here. When the Pilgrims landed at Plymouth Rock, the people that were watching them for a period of time and helped them learn what to harvest and how to harvest it, what to kill and how to preserve it, how to deal with what was medicinal, and the people that did that were Native Americans. And I don't think any of us should ever forget it. But no,
Well,
I don't think we should give it back to them.
Good, thank you. I am speaking to the legal property rights that are involved, Mr. Hastings. And I'm glad to hear that you do not advocate returning the entire United States of America, lock, stock, and barrel, to the
No, but I
native
do
tribes.
believe in sovereignty, even though we had a very contentious issue last year. But I believe in sovereignty. I happen to represent two tribes, the Seminoles and the Miccosukees, and my great-grandmother was Creek. Therefore, I have a bloodline interest as well as a continuing interest in the preservation of that sovereignty of those people that have been abused right there in the county that I represent in. They had to go to somebody, and we now make a deal for them to be able to allow gambling. If I were them, I'd gamble until I was blue in the face if I wanted to. They have a right on their reservations that we put them on. And no, I don't think that everything should be given back to them, but I think we should acknowledge at least their rights, and particularly in something as important as the matter here. In addition, Mr. McClintock, I think this matter, you say the courts decided it, and I believe that the Supreme Court did give the gradient position in the 1920-plus decision. But at the very same time, whatever we do here is likely to be litigated some more, and I don't think that we should be in the position of telling the Bureau of Land Management how to go about their surveys to help reduce the confusion that has existed in this. And I'll yield back the balance of my time, Mr. Chairman.
Thank you. Does the gentleman from Alabama have any questions, Mr. Byrne?
No, sir, Mr. Chairman.
Gentleman from Washington.
Thank you, Mr. Chairman. And I guess I'm trying to get my head around that. I've not been to this area of the state of Texas or Oklahoma. So at issue is a court decision back in 1923 and a boundary that was determined at that time and now has been questioned. Is that the right term from the Bureau of Land Management?
The Bureau of Land Management is asserting ownership over land according to an estimated survey done by means other than those criteria established by the Supreme Court in 1923 when these boundary lines were established. They basically changed the rules 90 years after that decision.
And this bill looks to correct that.
Exactly.
Okay. So it's a difficult, complicated issue, but it's could be boiled down into
It's
that.
not that complicated. People lawfully owned this land for 90 years, according to the survey that was established by the United States Supreme Court. 90 years later, after making no claims on this land, the BLM suddenly steps forth and says, oh, we're going to change the rules that establish these boundaries, and guess what? All of you landowners along this 116-mile stretch of river, you no longer own the property you thought you owned. That's the wrong that this bill rights.
And then there is some provision, at least in one amendment, and then a potential amendment that would protect tribal property rights as well.
Actually, several. It brings the tribes into full consultation on the survey.
That's right.
And any land that is disputed, owned by a tribe gets the right of first refusal. The problem is they're attempting to get right of first refusal over all of the land, including that to which they have no legal claim.
Okay, thank you. Mr. Polis, do you have any comments on that?
Well, by nullifying the BLM survey, it basically gives authority, carte blanche authority to the Texas General Land Office to conduct what would then become a binding survey that would move the border northward, potentially eliminating a large portion of estimated federal land holdings, which, again, as custodians of taxpayer money, we have an interest in here without receiving market-based compensation in lieu of fire sale. And of course, as mentioned, the tribes have an interest in. So it's a big unknown to give this kind of broad authority to a state general land office and in fact nullify all of the federal surveys, which this bill does.
The gentleman forgets one important point, and that is that the Texas Land Survey has to be done in accordance with the 1923 Supreme Court decision that the federal government has simply chosen to ignore.
Thank you, Mr. Chairman. I have no further questions, so thank you.
Thank you. I'd like to thank the gentleman from California and the gentleman from Colorado for being here and advocating on behalf of the bill and their positions. We'll now call on the gentleman from, you're both excused, and we'll call on the gentleman from Colorado, or the gentleman from Oklahoma, I'm sorry, to, you are recognized to speak to your amendment, Mr. Chairman.
Thank you. Certainly in football season, you want to be from Oklahoma, not Colorado. So thank you for correcting the error. Let me begin with a couple of comments, and I have both a prepared statement and some documents for the record. And I want to thank my friend, Mr. Thornberry, for genuinely trying to solve a knotty. This is a real problem. This is not a manufactured problem. And he certainly worked in very good faith with us and has made some changes. We would like to go a little further, but I appreciate, frankly, the changes that were made. I want to thank Mr. Bishop, who also worked with us. Now, in full disclosure, the original legislation did not include Oklahoma. That was a change that we got. So I'm glad they incorporated, and the original legislation did not acknowledge any tribal interest here. And that was, again, a change we got. But we would like to go further, but I want to begin by acknowledging, again, the efforts in good faith made by Mr. Thornberry and certainly Mr. Bishop to try and work with us, and those are deeply appreciated. The stated purpose of H.R. 2130 is to provide legal certainty to property owners along the Red River in Texas. While the stated purpose is well-intentioned, the effect of the legislation stands to significantly diminish the surface and mineral interests of tribal nations with lands adjacent to and surrounding this portion of the Red River. H.R. 2130 will require Texas and Oklahoma to conduct a survey, the goal of which is to ascertain the exact location of the portion of the river currently owned by the BLM. It's all but guaranteed that in this new survey, it will result in a determination that some BLM land exists on tribal lands and will be sold via 3 processes for disposal set forth in the bill. The first is to apply for a patent to the BLM land. The second is a sale based on a right of first refusal structure. Any remaining BLM land is sold via the competitive sale process. My amendment seeks to accomplish the following. 1, to ensure that the tribes receive notice of their right of appeal and any survey conducted. 2, to disincentive fraudulent patent applications to BLM lands that would hinder the process of disposal and the tribal opportunity to purchase. 3, ensure that tribes are provided with the rights of first refusal to the purchase of BLM lands, and 4, explicitly ensure that any survey and/or subsequent purchase does not result in any diminishment or alteration of any tribal or surface right. I don't want to take issue with my very good friend, Mr. McClintock, who's good on these issues, but this is an area I know a lot about because it's in my district. So I've been there a lot of times, and I'm certainly acquainted with the tribal interests, and I'm also acquainted with non-tribal landowners who, again, have this difficulty in a knotty situation of claiming, determining what their land rights are. This is a little bit more complex than a 1923 Supreme Court decision. This land was not just owned by these tribes, quote, in time immemorial in some imaginary past. This was their reservation. This was land that was, they held by treaty right to the south bank of the river, which goes all the way back to that was the boundary between Spanish possessions and American possessions in the 19th century. And so when they were placed there in the reservation, they assumed that boundary. And so their interests here are long and well established. And just to be quite honest, they did not consent to their land to be opened up to white settlement and into allotments. That was not so. To say they have no claim because the federal government effectively took their claim away from them, allotted their lands partly to them, paid them a pittance, and then opened up the settlement to others, I think is to sort of ignore the sad and hard lessons of history here. And we don't think it's unreasonable to ask that on BLM land they have right of first purchase, which, by the way, they've said shouldn't be $1.25 an acre, should be full market value for the land, which would be around $1,500 an acre. And they're not saying they would exercise it. They're just saying that since this was historically theirs, it was taken from them. They think they ought to have on BLM land. We're not talking about land that's held by other people now. That's in fee simple. That ought to be. They ought to have the right to purchase that. To them, it's reconstituting part of their historic reservation. The mineral right issues are real. There is a substantial income here, particularly given these are relatively poor tribes. These are not Comanches, Kiowas, and Oklahoma Apaches are not wealthy tribes. So them guarding their interest here, where they do drive some revenue and they have the potential for more, we think is reasonable. And to be frank, has been largely accommodated in the legislation, which again, I want to thank Mr. Thornberry and Mr. Bishop for. So with that, we would just simply like to amend the legislation along the lines that I outlined, Mr. Chairman, and be happy to answer any questions you might have.
Ms. Cole, thank you very much. Ms. Cole, at the time that the hearing was held, trying to look for a date, I don't necessarily see one here. Was this information provided to the committee that you were speaking about?
I'm not sure that the tribes were aware of all the information. And by the way, I do have their statement. Let me ask this quickly, Mr. Chairman.
Good. Without objection,
provide for
let's
the
put that
record.
into the record.
And
Yes,
that's
sir.
from
Thank
all
you.
3 tribes. We also have individual statements that are arriving, and if you could indulge us, we'd try to get those to you literally today. Some of them just arrived. So again,
Mr. Cole,
these are.
what we'll do is we'll leave the record open for the receipt of those, and without objection, those would be entered into the record.
Thank you very much, Mr. Chairman. So I'm not sure exactly what both the author and certainly the Natural Resources Committee had. I know these things are difficult and complex. I don't know if we got them everything in time. We've certainly been notified this as it progressed, and again, I'm here at the request of the tribes that I represent, and they've got serious concerns. They've looked over. This has been their effort at amendment. They think this is the appropriate way to go, and so we think they ought to be heard and have their opportunity to present their argument and their case on the floor on this legislation.
Thank you very much. Mrs. Fox.
Thank you, Mr. Chairman. I have no questions. I yield back.
Thank you.
Thank you very much. Mrs. Slaughter.
I have no questions, but I hope you'll make that, Mr. Coleman.
Thank you very much.
Any conversation, questions that might come? Thank you very much. Dr. Burgess.
Yes, Mr. Chairman, thank you. Just for clarification, you used the wording of a fraudulent patent to the land. How would that be proven?
Again, you'd have to go to court to establish it. I think if we pass this, particularly without the amendment, there's going to be a great deal of litigation. Because it's not as if they're going to accept this. We'll be headed to court. I actually think that'll provide, in some ways, more uncertainty. With the amendment, we think we have a much greater likelihood of avoiding extensive litigation.
But there's nothing in the legislation that would prohibit that litigation.
No, I don't believe so. Not at all. Not at all. And I don't think there's ever any attempt to do that. Again, I think people here are operating in good faith. I really do, on all sides of this. And I've got constituents, to be honest with you, on both sides of this issue. But I do think it's very complex. I do think there's a lot of history here. I do think originally, again, entities like the state of Oklahoma and tribal governments weren't thought of here. This is a disputed area, and historically, again, one side would argue, hey, the real boundary of the Red River is on the south bank, because that's where it was when our reservation was created. That's where it was when Texas was part of the Spanish Empire, and after that, the Mexican Empire and the United States international border was indeed the Red River. I mean, that was the claim we asserted back then. So. Again, it'll take a Solomon to sort out some of this stuff, to be honest with you.
I would agree with you. There's a lot of history. Thank you, Mr. Chairman. I'll yield back.
Yes, sir. Is there any other member that would seek time? Gentleman from Washington.
Well, thank you, Mr. Chairman. And Mr. Cole, just appreciate your testimony and helping us understand that with the amendment you're proposing, would then passage of the bill right the wrong that is being pointed out here?
I think so. From the tribal viewpoint, they fully support the amendment. And in full disclosure, we certainly worked with them to try and arrive at something. But again, I want to tell you that my friends, Mr. Thornberry and Mr. Bishop, worked in very good faith as well. And they may have a different view of this. As Mr. McClintock argued, he would argue that this is an overreach and that real legal ownership started 90 years ago. There's a case to be made for that. But remember, those boundaries weren't recognized by the tribal entities involved here. They never consented to those decisions that were made. And again, they'd been guaranteed that land, in perpetuity, and we as a federal government reversed ourselves, and it created, an enormously difficult situation for them. It creates, I would acknowledge, a difficult situation for property owners today. So we think this will let us sort it out, and again, there is a BLM claim here. There's also one other item I'd like to add that I should have mentioned in my testimony, Mr. Chairman, and this agreement covers roughly half the Red River border between Oklahoma and Texas, and I think to the 98th meridian. We have a challenge. I represent part of the other part of the Red River, too, where the Chickasaws and the Choctaws have claims. And they see this as if you do this here, then it's coming our way on our side of the river. And so there is a genuine concern. Now, this legislation does not affect that area, to be clear. And again, my friends worked very hard to make sure it did not. And in full disclosure, as a member of the Chickasaw Nation, I obviously have a pretty strong view about that. On the other hand, we see the precedent, if it's established for one half of the Red River, then we have mineral claims, water claims. We're in litigation with the state of Oklahoma right now over water. Texas has been involved in that litigation at some point and certainly has a direct interest. We're in federal mediation now. So we're pretty careful about claims being established along this portion of our historic boundary.
No further questions. Thank you, Mr.
Thank you. Thank you very much. Mr. Cole, thank you very much. I would like to allude to the ongoing relationships between Oklahoma and Texas with great respect to the tribes that are there and both sides. I thank not only you and other members of the delegation, but also certainly our North Texas delegation that are involved in what I believe are straight-up conversations that people have with each other. As I told you about this, I would hope to make this amendment in order I notified the gentleman, Mr. Thornberry, to his staff the other day that I would be making this an order.
Well, I appreciate that very much, Mr. Chairman. Again, I want to state that the efforts have been very much in good faith, and I certainly regard them that way. And outside of our occasional disagreements on a football
Well, that's in
field in
October.
October, which you won, I got to tell you, there's no better neighbors in the world than Texans when you got problems. We've had a lot of help in our neck of the woods and tornadoes and disasters that comes right up the Red River, across the Red River to us. And seeing you extend the same courtesy to our friends in Louisiana and Hurricane Katrina. You got a tough problem. You want Texas as a neighbor and a friend because they certainly come through for you.
Yes, sir. But also, we recall 97, 98, 99 with truckloads of hay that came from Oklahoma, Sooner Nation. We recognize that, and our cattle appreciated it, too.
Thank you, Mr. Chairman.
Ms. Cole, thank you very much.
Thank you.
Is there any other member that would seek time to discuss H.R. 2130? Seeing none, this now closes. I'm sorry. Yes, ma'am. Okay, thank you. This now closes the hearing portion of H.R. 2130, and the chairman would now be in receipt of a motion from the gentlewoman from Grandfather Community, North Carolina.
Mr. Chairman, I move the committee grant H.R. 2130, the Red River Private Property Protection Act, a structured rule. The rule provides 1 hour of general debate, equally divided control by the chair and ranking minority member of the Committee on Natural Resources. Rule waives all points of order against consideration of the bill. The rule makes an order as original text for the purpose of amendment. The amendment in the nature of substitute recommended by the Committee on Natural Resources now printed in the bill and provides that it shall be considered as read. The rule waives all points of order against that amendment in the nature of substitute. The rule makes an order only those further amendments printed in the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in the report. The rule provides one motion to recommit with or without instructions. Finally, Section 2 of the rule provides that it shall be in order at any time during the calendar day of December 13, 2015, for the Speaker to entertain motions that the House suspend the rules and that the Speaker or his designee shall consult with the minority leader or her designee on the designation of any matter for consideration pursuant to this section.
You now heard the motion from the gentlewoman from North Carolina. Is there amendment or discussion?
There is.
Gentlewoman's recognized.
Thank you very much, Mr. Chairman. I have an amendment to the rule. I move that the committee add a section to the rule that provides for consideration of H.R. 1076, the Denying Firearms and Explosives to Dangerous Terrorist Act of 2015 under an open rule. Mr. Chairman, as you know, there's a disturbing loophole in our laws which allows suspected terrorists to walk into any store and to purchase firearms. Over the last 11 years, this dangerous loophole has allowed more than 2,000 suspects on the FBI's terrorist watch list to buy guns in the United States. In fact, more than 90%, that's nearly all, of suspected terrorists who attempt to purchase a gun walked away with a weapon that they wanted. Mr. Chairman, too many people have lost their lives to preventable gun violence. And we in the House continue to hold moments of silence. Yes, as we stand in a moment of silence, we are the people who can make a difference. But we fail to take any meaningful action. And in the wake of the tragedies in San Bernardino and Paris, it is imperative that Congress come together to close this glaring loophole and keep deadly weapons out of the hands of suspected terrorists. And I need to add that this bill has been written and sponsored by my colleague from New York, Peter King. And I ask for a yes vote.
Thank you very much. Further discussion. Gentleman from Massachusetts.
Yeah, Mr. Chairman, I just want to add my support to the gentlelady's amendment. And I heard some of the back and forth on the floor during the last procedural motion, and it And some on the Republican side seem to suggest that this was just some idea that the Obama administration concocted, this idea of keeping weapons away from people who are on the terrorist watch list. But the reality is the Bush administration felt the same way. The Bush Justice Department proposed legislation that would give the Attorney General discretion to bar terrorism suspects from buying firearms, seeking to close a gap in federal gun laws. Republican former New Jersey Governor Tom Keene, who was one of the authors of the 9/11 report, has admonished Congress for not closing this loophole. Former FBI Director Robert Mueller has also called for closing this loophole. Richard Clark, counterterrorism expert in the Bush administration. Former NYPD Commissioner Ray Kelly, the International Association of Chiefs of Police. And I get it if people, want to vote no on it, but I think this is an important enough issue that we ought to at least be given an opportunity to vote up or down on it and not have to rely on procedural motions. I think everybody ought to go on record on this issue, and I hope that we will make the Slaughter Amendment in order, and I yield back.
Thank you very much. Further discussion?
Yes, Mr. Chairman.
Judge, you're recognized.
Mr. Chairman, I support Ms. Slaughter's amendment and really beg that it be made in order. It's no secret to us that H.R. 1076, the Denying Firearms and Explosive to Dangerous Terrorists Act of 2015, has been out there for a little while. Representative Peter King, a Republican colleague and friend of ours, filed this bill to close a loophole that allows terrorist suspects to legally buy firearms and explosives. Let me put a fine point on Ms. Slaughter's point about 90+% of cases that the GAO analyzed. Individuals on the federal terrorist watch list have tried to buy or obtain a firearm or explosive or license or permit at least 2,233 times. And they were successful in 2,043 of those cases. In my view, this is a common sense, life-saving bill to keep guns out of the hands of terrorists. And let's be fair about this. Nothing, absolutely nothing, is going to stop some people from getting guns. But as for example, thinking that this came from President Obama ignores the fact that many of us that were here since 1992 voted on measures that were similar, and an even more important one, the banning of assault weapons. I defy anybody in here to tell me why any person that is non-military or law enforcement has a need for the kind of weapon that was just used in San Bernardino, California, and has been used in other mass shootings. I don't think that's right. I think we're a better people than that. And gun manufacturers obviously have a vested interest in their business, and I respect that, but at the same time, they could make a living without having the kinds of repetitive firearms that are on the streets of our nation. Australia did an interesting thing that was a buyback, and I don't advocate that. But I wish people would get over this notion that there's going to be some massive takeover of the guns of people in this society. I've said here, and I'll say it again, I own a weapon that's registered with the authorities, and I have no fear that anybody is going to come on any given day and take my gun. I really don't understand how people come to that conclusion. As a matter of fact, for those of us that don't know, or those of you that don't remember, the National Rifle Association, when I came here in 1992, was a sportsman organization. And it has morphed into what it is today, which is a shill for gun manufacturers. And it's just that simple. They have that prerogative, and so do the gun manufacturers have the prerogative to use the process as they have been doing. But it doesn't mean that it is right, or that those of us that have in our constituencies people that are at the mercy of the system that allows for this kind of purchase of firearms or explosive devices, for them to know that we at least tried to do something. The only people that don't seem to support H.R. 1076 House Republicans who voted 3 times last week to prevent even debating H.R. 1076. I just, for the life of me, do not understand why, as Ms. Slaughter put it, that we continue to offer our thoughts and prayers, as rightly we do, have a moment of silence. And I sit there often and I think, oh, well, we'll go back to our business as usual and our usual banter and important things that we do on the floor of the House of Representatives. So I decided last week, not out of any disrespect for persons who are killed, but I'm not standing anymore for any moments of silence. And I suspect that if we don't pass measures like this measure that Ms. Slaughter's amendment calls for, that we will be back in the thoughts and prayers and moment of silence business. And to my way of thinking, we're a better nation than that and should not allow ourselves to fall into a trap that lets a group of gun merchants control our legislative prerogatives. They won't control mine. I hope I get minus zeros every time the NRA makes their markings, largely for the reason that I think it's wrong for them to advocate measures that we know kill people and cause more people to die. This is a common sense approach to a now problem that we have manifesting itself in San Bernardino last week and likely to demonstrably show us again when it happens. I guess one day when one of our offices gets shot up, taking the young lady out in Oklahoma off the table for a moment and an outdoor thing, but the day may come that some group comes to our offices and kills up a bunch of our people, then perhaps we will give some thought to it, or maybe we're so callous that we won't. That is regrettable. I yield back the balance of my time.
Thank you very much. Further discussion?
If I may add.
Yes, ma'am.
I hope that everybody saw the weapons removed from the home of Malik Farouk. There were enough bullets in there to kill half of San Bernardino. And I understand that they can also modify those AR-15s so that you only pull the trigger once and it just continues to shoot. It would really be a wonderful gesture for this time of year for all the children who have lost a parent to gunshots and children who've killed themselves. I remember the hearing recently of a toddler who found a gun in the back pocket of a car seat and killed his grandmother with it. In the name of those orphans and children and widows and everybody else out there, there are over 340 mass killings this year. It would be really nice if the Rules Committee could allow this to come to the floor to vote. So I really would ask for a yes vote.
Further discussion? Mr. Stivers?
Mr. Chairman, I want to enter into the record a editorial from the Los Angeles Times today that spoke to this amendment because it was originally offered in the Senate by Senator Feinstein. And just to make a few really quick points. Number one, terrorists will always find a way to get weapons. The 2 suspects in San Bernardino got their long rifles from other people. They did not purchase them through any legal means. They got them from other folks. And the question isn't whether terrorists are going to get weapons. It's about whether law-abiding folks are going to get weapons. And with regard to the list, you know, we have a due process under the Fifth Amendment to the Constitution and a Second Amendment right to keep and bear arms. And the Supreme Court decided that the amendment applied to individuals keeping and bearing arms, and it also applies due process to people. Normally, we don't say to people, you're a suspect, therefore your rights are taken away. We normally give people due process. In fact, that's a constitutional right, and it's very important. And third, the no-fly list is a secret list. You get no notification when you're on the no-fly list. In fact, there are many errors on it. And Ted Kennedy, very famously in 2004, was hassled at the airports because somebody with the initial that went by an alias initial T. Kennedy was on the no-fly list, and it took him months as a U.S. Senator to get off the no-fly list. In fact, I believe the American Civil Liberties Union has sued the United States government for the numerous flaws in the no-fly list, and we need to all take that very seriously. And finally, the impact of how it would work is there are about 1.1 million people on the no-fly list. Most of them are foreign nationals who do not live here. About 10,000 of the people on the no-fly list, we believe, again, this is according to the Los Angeles Times, are either American citizens or permanent residents. And the other folks who are not permanent residents or citizens already are barred by federal law from purchasing handguns. So the impact we're talking about here is around these 10,000 citizens and permanent residents, most of them citizens, and whether we should take away their constitutional right and their right to due process. We're waiving 2 of their rights under the Bill of Rights for a list that's secret and has no adjudication. And that's the problem. So there's a whole bunch of problems with this. And, you know, this is no conservative bastion. It's not the Wall Street Journal or some conservative paper. This is the LA Times that did an editorial today saying why this is bad policy, and they agree with the goal here, but I just wanted to, and I will submit that LA Times, I've got it on an email, I'll shoot it to you to submit it for the record, Mr. Chairman.
Mr. Chairman?
Thank you very much, Mr. Savage. Yes, sir.
Yeah, just for the record, there is a process, if you were on that list, to get off the list. But I would be willing to bet that the vast majority, the overwhelming majority of people who are on the no-fly list are there for a good reason. They're not allowed to fly on airplanes. And as somebody who flies back and forth to Boston every week, I am glad that people who are suspected of being terrorists are not able to fly on the same plane that I am. I would feel a lot better if they couldn't buy weapons, as well. And I don't care if it's 100 people. I think the majority of Americans, I think, would feel a lot better if, in addition to not being able to fly on an airplane, they couldn't buy a weapon as well. So I respectfully disagree with the gentleman.
Would the gentleman yield?
And I will. And again, nobody here is suggesting, as my friend Mr. Hastings said, that this solves all the problems. To deal with this issue, there are many things that we need to do. But listening to some the rationale from some of my colleagues, I mean, we have speed limits on our roads. That doesn't mean that people don't speed, but I would argue with you that because we have a speed limit, that we have saved a lot of lives. You can't drive drunk on our highways. That means people don't violate the law, but as a result of that law, we've saved a lot of lives. And I think that we need to, and again, not just regard to this particular issue, but there needs to be some rationality here. And the idea that we can't even agree that that no one here is arguing that we repeal, maybe you guys are that we should repeal the no-fly list so that nobody can be banned from flying on an airplane. If that's what your opinion is, then I guess your opinion with regard to guns is more consistent. But if you believe there ought to be a no-fly list where suspected terrorists ought not to be on our airplanes, then it's hard for me to believe that you can think that it's okay to sell them guns, given the fact that there is a process in place once you're on that list to be able to get off of it. And I thank the gentleman. I yield to the gentleman.
Thank you. I appreciate it. The big difference is there's no constitutional right to fly on an airplane. And when you're messing with the Constitution, we raise our hands and say we pledge to uphold the Constitution of the United States when we get sworn in. And so it might be difficult sometimes. It might not be what we want. There are some things, that all of us maybe would like to do that when you think about whether it's constitutional or not, that's a problem. And so we live in a constitutional republic, and I know that means it puts limits around what we can do. Right. And that's a problem for some folks, I understand at times,
No, yeah.
all of us, but it is, those rights are fundamental. And so we need to make sure we can uphold the rights of our citizens while also fighting terrorism. And I believe we can do both. I don't think we should abrogate our citizens' rights in order to secure our population. There's a way to do both, and we need to do
Well,
both.
I'll just say to the gentleman that time and time again, we have sacrificed the rights of our citizens with regard to privacy, with regard to due process, you know, and even within the constitutional rights we have, there are limits. I mean, we have the constitutional right to freedom of speech. You can't you can't walk into a crowded movie theater and shout fire. And so that there are rational and reasonable constraints. And I don't, you know, and we could all have different interpretations of what the Second Amendment guarantees people. But no matter how many times I read it, I don't believe that it guarantees somebody the right to buy a weapon of war that is designed only to kill somebody on the battlefield. But having said all that, if people think this is a bad idea, then they can vote no. But we ought to have the opportunity to bring it to the floor and vote on it. And with that, I yield back and urge a support of the Slaughter Amendment.
Thank you very much. I have an opinion. I think almost all of us do. You know, one of the opinions that I've got is whether we really should just say to people, as this man did, he owned weapons. He didn't go buy them, but had them. And maybe what we ought to say is they're not allowed to have any weapons. Is that more to the point? But he evidently didn't buy them.
If the chairman will yield. Has the investigator concluded yet why he had all of the rounds of ammunition and where they came from?
No, I tell you, I've not studied this. I just saw where he received $28,000 or $30,000. That I don't know where it came from. I don't know.
Right on.
All I'm trying to say is he didn't purchase them, probably.
He purchased, well, excuse me, he got them from someone else. But we don't have to isolate on this guy. He wasn't on the watch list that we're talking about.
And nor was he on the watch list.
But those other persons who were, that went on to purchase weapons, the authorities have made that determination. And it begs the question that I continue to ask, why would anybody need thousands of rounds of ammunition? I just, for the life of me, don't understand that. Why can't we have identification of ammunition so that it helps the authorities when a violation occurs? Evidently, you people are living in a world where people aren't being killed. And I'm living in a world where they are every week, and where assault weapons are on the streets of Fort Lauderdale and Miami and West Palm Beach. And for the life of me, I don't understand why that's the case. Why are they made? What are they for, other than to kill people? And that's where I'm coming from. I don't care where this guy got his garbage from.
I appreciate it. So further discussion, seeing none, the vote now be on Slaughter Amendment. Those in favor signify by saying aye. Aye. Those opposed, no. No. Noes have it, noes have it. Gentlewoman asks for a roll call vote.
Ms. Fox. Ms. Fox, no. Mr. Cole. Mr. Cole, no. Mr. Woodall. Mr. Woodall, no. Mr. Burgess. Mr. Burgess, no. Mr. Stivers. Mr. Stivers, no. Mr. Collins. Mr. Collins, no. Mr. Byrne. No. Mr. Byrne, no. Mr. Newhouse. No. Mr. Newhouse, no. Ms. Slaughter. Aye. Ms. Slaughter, aye. Mr. McGovern.
Aye.
Mr. McGovern, aye. Mr. Hastings.
Yes.
Mr. Hastings, aye. Mr. Polis. Aye. Mr. Polis, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 9 nays.
The motion is not agreed to, further amendment or discussion. Seeing none, the vote will now be on the motion from the gentlewoman from North Carolina. Those in favor signify by saying aye. Aye. Those opposed, no.
No.
Ayes have it, the ayes have it. Accordingly, the gentleman, Mr. Newhouse from Washington, will be handling this for Republicans. Mr. McGovern for Democrats. I would wish to say to our members that I believe that enough information is out, although I don't know the exact plan is of the schedule, but it has been, I believe, well understood and announced that we would be available for votes throughout the weekend. As we have done consistent with this rule, we have made suspension bills in order through Sunday, December 13th. I do not know the status of when things may need to come back to the Rules Committee. As always, I would stay in touch with Mrs. Slaughter and certainly Miles and the great Hugh Halpern, the spy from Altoona, Pennsylvania, for Mr. Schuster, would make sure that he is talking about any action that would need to take place. And otherwise, we'll move through the weekend, allowing committees, committee members, and others to do work that's necessary to complete our work. But we are going to, the plan is that we will, as a body, stay here until we complete our work to then go home. So that's where we are, and until we find something happens, we'll be ready for action as is necessary. Further discussion. We are going to make ourselves available, and it's my understanding, stay here until we finish. I'm sorry? Oh, yeah, that's, you'll be given chances that also. This completes our work for the day.